Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a warm hello to everybody in between. My name, as you can see on the screen, is Dan Balkaran, and I will be your employment lawyer for the next 30 minutes or so. I am, as you can also see on the screen, I am an associate at Canada's leading employee side employment law firm of Samfiru, Tumarkin. A couple housekeeping notes before we get going. If you need to get a hold of us, you can do so at help@employmentlawyer.ca. We have a great website up at employmentlawyer.ca. It's filled with informative stuff, the latest news on employment law, blogs, everything else. You should certainly check it out. It's very helpful. And you can email us, as I said, at help@employmentlawyer.ca, or you can call us at 1-855-821-5900. And if you need to get a hold of me as well, you can do that via one of those avenues. Okay, let's get into the questions. We've got a couple of them rolling in here. Let's see here. Clayton asks, my sister is currently on maternity leave, and she's been told that she'll have to apply for a new job position with her current employer when she returns. Is that right? Is her job not guaranteed? Well, yes and no. I mean, if the job is eliminated due to the normal course of business, they don't have to hold it for your sister just because she got pregnant. But they cannot discriminate against your sister because she was pregnant. So because of a human rights protected ground, in this case, it would be her sex. And so discrimination on the basis of the fact that she's a woman because she's a woman, which is, tied in with being pregnant. So you need to find out if there was a business reason for this, or if they just took the job away from her because she was away when she was pregnant, gave it to somebody else and said, no, you can't come back to it. And because she can't come back to it, she has to apply for another job. And so, apply for another job also has the connotation of that she might not actually have a job and to return to, which could, open up a wrongful dismissal complaint as well as a human rights complaint for being discriminated against on the basis of sex. Clayton, you need to talk to an employment lawyer. I can't, I've given you sort of the basics, but it's, the human rights code is the human rights protection legislation is provincial generally, unless your sister is federally regulated, which very few employees are. And there are some variations. I mean, not much, but between provinces, you absolutely need to talk to an employment lawyer on this one. If you need to talk to us, you can do so. help@employmentlawyer.ca, 1-855-821-5900. But I will say, Clayton, that it's always dangerous for employers to get rid of a job, for somebody who is on medical leave, because there's not quite a presumption, but there's a strong inference that, she lost the job because she got pregnant, and that's just a no-no. It cannot happen at law. So, definitely talk to an employment lawyer as soon as you can. This is the same question from Clayton. Okay. Rocket asks, when an employee gives up their rights in an employment contract and gives it to the employer, can the employer forfeit those privilege rights by not exercising them when they see fit? I don't quite understand the question, Rocket, but I'll try to answer it based on how I understand it. So what an employment contract is it's an agreement between two parties. It's just like any other agreement. So Rocket, if I decide to sell you, or if we decide that I'm going to sell you my bike for $20, my bike goes to you, goes one way, and $20 goes the other way. It goes to me. And once those things are exchanged, we have a finished transaction. Okay, so we've agreed to exchange bike for $20. Now it's a one-time, it's a one-time transaction. Bike and money exchange hands, and we never have any interaction again. However, in an employment relationship, what's happening is you're exchanging your labor for money on an indefinite basis. Okay, so the difference between that and my bike example is time. It's in perpetuity. Okay, and so the core of that agreement, even if you don't have an employment contract, the core of the agreement between the two parties, between the employer and the employee, is that you go to work for a certain amount of hours to do a certain amount of duties in exchange for a certain amount of pay. Okay, that's the core of the employment contract. That sort of lives in the air between the two of you, we'll say. What the parties can choose to do to ensure certainty of and therefore enforceability of terms is they can take some of the terms of the contract of employment that lives in the air between the two of you and write them down on a piece of paper. Okay, and that's called an employment contract. And what an employment contract 99 times out of 100 is it's the employer exploiting its superior bargaining power over the employee at the time of contract formation to force the employee to agree to terms, contractual terms, which are contrary to the employee's best interests. Okay, that's what an employment contract is. It's for the employer's benefit. It's not for yours, the employees. Now, I mean, it can be if you're I've worked with doctors, high-powered doctors, and CEOs and so forth, where they have a lot of leverage and can dictate to a large degree what goes in to the employment contract, in which case it's a much more sort of mutual bargaining. But 99 times out of 100, it's not. You're an employee, and if you want the thing that the employer has, which is the job, you're going to take the terms that they give you. And so in my line of work, what I do most commonly, it comes into play in the form of a termination clause. Okay, so by default, you get what's called reasonable notice upon your termination. So that's if it's really an entitlement to a heads up, like, hey, Rocket, you're going to be terminated. You're going to be terminated in the future. The bad news is you'll no longer have a job. The good news is we're going to continue to pay you for however long that time is. Say it's 6 months, and you can continue to draw a paycheck from us, and we'll give you time to look for a new job, and hopefully you're not unemployed for very long, if at all. That's what you're entitled to, notice. But 9 times out of 10, the employer will choose to just terminate the employee rather than give them notice, because an employee who knows they're going to be fired is a sabotage risk and a morale risk for the remaining employees. And plus, you can pay the employee less because an employee will take 60 cents on the dollar if they don't have to work. And so even though your only entitlement is to notice, if the employer chooses to pay you out that amount of time that you would have been given in terms of notice, which is called severance, it's just notice where you don't have to work the time out, well, they will choose to pay severance most of the time. And so where it comes up with what you're talking about, most of the time is in termination clauses in employment contracts, where it limits. I said just a minute ago that you're entitled to reasonable notice. Reasonable notice, or pay in lieu of reasonable notice, is it's approximately 1 month per year of service. It's not quite like that. There's a lot of play in those joints based on your age, your length of service, the nature of your employment, and how long it'll take you to find a new job. But it's still quite a hefty amount. You've been there for a long time. You might be looking at a maximum of 24 months of severance. 2 years of pay upon termination is a substantial amount of money. And so what employers try to do is they try to limit your termination rights to the statutory minimums, which are in most cases 8 weeks, which is substantially less than 24 months. So I don't know what you mean in terms of forfeiting the rights in an employment contract. So, if it chooses not to enforce the rights in a contract, is it then barred by estoppel from the rest of the contract? No, I would say no. And in fact, a lot of contracts contemplate that. But Rocket, if you can clarify, I don't exactly know what you're referring to. Martin asks, can you explain what severance entitlements are for federally regulated employees? I work in a federally regulated industry. It's a great question. So if you don't have an employment contract, or your contract doesn't properly, we'll say, eliminate your right to reasonable notice, which is what I just explained. Another way to say that is common law severance. Then you would be entitled to that common law severance. So if your contract doesn't limit you in some way, you're entitled to common law severance. However, federally regulated employees are a complicated animal. You have different, almost union-like protections under the law, and so you have, if you've been fired as a federally regulated employee, you can apply within 90 days, but it's a hard cut. It's a hard 90 days. You've got to meet it. So you've got to move quickly, talk to an employment lawyer right away. You can apply to the, I always forget the name of this, but the Canada Labor Code Tribunal. Canada Labor Code is the governing statute for federally regulated employees, to the tribunal that decides unjust dismissal claims, and make a case for either back pay or reinstatement. That is one remedy you can go. There's also a case called in 2017, I think from the Supreme Court of Canada, called Wilson and Atomic Energy. That seems to say that you can't be dismissed for what are listed as the minimums within the Canada Labor Code, the severance minimums, we'll call them, within the Canada Labor Code, and therefore that dismissal, effectively, if that's what you were provided is or provided for in the employment contract, sort of voids the employment contract, or at least the termination clause of it. And so therefore you should be able to sue for reasonable notice. That is a much more new ground, and it's something you certainly want to talk to your employment lawyer about. It's quite complicated, giving you a complicated set of answers, which not all of which were satisfactory, but it is a complicated area. And I would say if you're federally regulated and you have been terminated, should, because of the 90-day window for pursuing an unjust dismissal remedy, you should contact an employment lawyer immediately. And again, you can contact us at help@employmentlawyer.ca if you want, and 1-855-821-5900. All right. This is just a it's not so much a comment as an endorsement. So this is someone watching from Hartford, Connecticut. Good day to you, Mr. Attorney. Keep up the good work, and thanks for the useful information on the law. I appreciate that. I'll take the compliment and run with it. I don't want to say this person's name because it's unique, and I don't want to give it away. So or breach this person's anonymity. But should I request an updated contract of employment after changing positions? My title and duties are very different, but I haven't signed anything stating this. No. This is a great question, and the answer is no, unless there's something you want to have like concretized in stone or contractual stone, as it were. You shouldn't, because you got to remember what I said earlier. All these questions today seem to join up and link together. The employment contract is not for your benefit. It's for your employer's benefit. It's there to limit your rights. It's there to limit your financial redress against the employer should the employer terminate you or otherwise act in a manner that, well, we'll just say terminate you. We'll leave it at that. But or constructively terminate you, and there's a few other things. But if you're working in a different position, you're working in that position. If they remove you out of that position, that could potentially be a constructive dismissal, depending on if it's a demotion or a hollowing out of that position. There's no need to place that in an employment contract. If you had a previous employment contract that limited your termination rights, maybe it doesn't really matter. Although if the position is radically different, if you went from mailroom to CFO, then that old contract would be eliminated by that change anyway. It'd be no longer applicable. But the point is, like, you shouldn't be in a hurry to have your employer limit your rights in an employment contract. If you're not sure about this, or there's something specific that you want to have covered off, you should talk to an employment lawyer. I know I sound like a broken record, but these things it's very complicated. It's a very complicated area of the law. It's not something that, and it's uniquely tailored to you. It's tailored. I mean, the law isn't tailored to you, but the facts in each matter are so different. You're going to want to talk to an employment lawyer. It's worth it to do so, just to make sure that your rights are accounted for. So again, help@employmentlawyer.ca, 1-855-821-5900. All right. I don't think I'm going to be able to answer this question, Rita. Toronto Police Service, which sent 100 plus officers home last November because they're not compliant with new COVID policies, has sent a letter calling them back, which is great, to work, but telling them they're responsible for both their OWN. I'm not familiar with that because I'm not called in Ontario, and employer portion of their OMERS pension. Can they do this? I mean, if their employment contract sets out that pension is part of their compensation, I would say no. I also, aren't they all unionized? If all those police officers are unionized, this is a question that needs to be directed to your union representative. I won't be able to. Their rights are going to flow from their collective bargaining agreement if they are unionized. If you're talking about non-unionized personnel, I would say generally that the police services are going to have proper contracts or a collectively bargained agreement. If it's a collectively bargained agreement, I'm not going to answer the question, or I would say I'm unqualified to answer the question. If it's non-unionized personnel and there's an employment contract involved, I would wager a lot of money that the employment contract covers the police services pension responsibilities as part of their compensation, in which case I would say, no, they're in breach of contract. It's just what is the remedy at that point? Because, and I sort of talked about it earlier, but as an employee, I mean, you can try to enforce. I mean, the police officers have a lot of leverage because there just aren't enough of them. And so, if there's a breach of contract situation, they can try to enforce the breach of contract, in a court of law potentially. But, if you're not, if a contract has been breached to the point where, from an employment remedy perspective, you claim, well, you've eliminated my compensation or a huge chunk of my compensation, I'm claiming constructive dismissal, then your remedy is severance, assuming, again, you're not unionized. But if your remedy is severance, you no longer work there. And most of these people want to continue to be police officers in Toronto. So it's an assessment of not only what is the law, what are your remedies, and what is it that you can live with and works with you from a non-legal perspective. So, Rita, first question I would ask is, again, are you talking about unionized personnel? If you are, talk to your union representative. If they're not, you're going to have to talk to an Ontario employment lawyer. I know I sound like a broken record today, but that's very complicated. And you're going to want to talk to an employment lawyer in Ontario. Again, help@employmentlawyer.ca, 1-855-821-5900. Okay. Pauline. I've been on medical leave and just been cleared to return to work. My employer said my position has been given to someone else and I will have to take a lower position and my salary will be reduced because of this. Can they just change my pay and position? Well, this is the question that I answered earlier. So no, you're entitled, if your position still exists, you're entitled to return to it. They have to give it back to you. If not, they're discriminating against you on the basis of a disability. So you have a human rights complaint. And if they don't put you back in your position, if they're close enough in terms of position, maybe there's something to argue about, but you can also claim that their refusal to put you back in the position is a termination of your employment. You could also claim it's a constructive dismissal, but I would say it's a termination of your employment. It's just, have you failed to mitigate by your losses? So you don't just get an unfettered right to, if we're talking about if you have a right to common law severance, you don't just have an unfettered right to common law notice. You can't just sit on your heels and force your employer to pay for your financial misfortune of losing your job. You have to make reasonable efforts to look for replacement employment. And so one of the best ways it's called mitigating your losses. One of the best ways to mitigate your losses from losing your job is to work in the job you just lost, or in this case, the alternative job that they've offered to you. And so, are you required to have accepted that job? It depends how much the pay cut is, and it depends, how big the demotion is in terms of prestige and so forth. So, the short answer is, do you have a human rights complaint? 100%. Do you have a severance claim? Yes. We don't know if your severance claim is a viable one, we'll say, because let me rephrase that. Can you treat this as a termination, and which would allow you to have a severance claim? The reason why I say it is you can't get severance without actually losing your job on a without cause basis. So yes, but if it's depending on if it's, but we don't know if it's viable because I haven't had a chance to look at your employment contract, and so we don't know if it limits you to the statutory minimums. If it doesn't, then you have a common law severance claim, and then the question then becomes, what is the degree in terms of the difference in pay and the difference in prestige and duties between the old job and the new job. So viable severance claim may be viable. Viable wrong human rights claim may be viable severance claim. As I'm saying over and over again today, you need to talk to an employment lawyer. It is complicated, and we have to review the specifics of your facts. Employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, Jose asks, good morning. I'm 1 month away from returning back to work from a 17-week medical leave. Wow, this is the medical leave day. I am not confident that I will have a job on return. Will I be eligible for severance or commissions owed? So you're not entitled to commissions owed over the period of time you didn't work unless you have a contractual situation where you get commissions on an ongoing basis. I have a client who gets commissions, or who got commissions even when he wasn't working, for, we'll say, contracts that he fulfilled that had an ongoing component. So in that case, you might, depending on what your contract says. You're entitled to return, just as I said to everybody else, you're entitled to return to your job. You can't lose your job because of a disability unless it's something like, a business restructuring, or they eliminate the position and no one's in that job. But like I said to Pauline, they can't just give your job to somebody else. So you have to find out if you say, okay, well, I'm ready to come back now, and they say you can't work, you don't have a job to return to, you got a human rights complaint, and you likely have a severance claim. It's just we don't know how viable it is, because I can't tell what's in your employment contract, and I don't know if its termination clause limits you to the statutory minimums or not, or if you're entitled to common law severance. So again, Jose, as I keep saying to everybody, you need to, Jose, nothing has happened yet, so you don't need to do this yet. But if you try to go back to work and they won't let you back in the exact same position you left, or they've reduced your compensation, or they demote you, saying you got to take this other job, or they fire you, contact an employment lawyer right away. Again, you can get a hold of us at help@employmentlawyer.ca, 1-855-821-5900. Okay. Pauline again. Martin, I can't remember. I think Martin might be the federally regulated fellow. My employer has stated we aren't owed severance at all because of our industry. Well, that's just not an accurate statement. There is no situation. So the American economy is a lot more Wild West than ours is, and it has a lot less protection at law for employees than ours does. They have something in the U.S. called at-will employees, which means you can just fire them and not give them anything. We don't have that here. At any point in time, if you're terminated without cause, you're going to be entitled to some severance. It might be small. It might be statutory minimums. And if you've only been there for less than a year, it might be 1 week. Okay. But, and a little bit different with federally regulated employees, but you get the idea. But you're never going to get nothing if you're terminated without cause. Now, if you quit, you get nothing. Or if you were terminated for just cause, you get nothing, provided that it actually was just cause. So it's a bad outcome for society if you're thrown out on the street with no money or no jobs. The law has evolved over time. This idea of I called it notice earlier, and that's what you're entitled to, but we'll just say severance because everyone understands it. You're entitled to severance, which is just some money to cushion your fall of being unemployed. So the law wants you to get severance, but there are certain legally justifiable ways in which the employer doesn't have to pay you severance. That's called just cause. And there are 3 ways to get to just cause. One is a single act that's so egregious the employer is justified in no longer continuing the employment relationship. That's your classic punch your boss in the face, coming to work high on drugs, theft, fraud, committing a serious crime, that sort of thing. The next way to get there is a series of performance or conduct failures, which you are provided clear warning of and an opportunity to correct same. That's your classic 3 written warnings and you're out. And then there's a third one called cumulative cause, which is just there's a basket of everything that occurs that just you're all around a bad employee, and therefore the company is justified in letting you go. That one is for nothing. That one is much harder to get to the longer you've been there. If you're a 20-year employee, it's hard to claim cumulative cause at that point, although it can of course happen. And so the core underlying this all, which is the test for just cause, is that the relationship of trust between the parties is broken down, and it can no longer continue, we'll say. So, if you do one of those things, you get nothing. But a lot of times employers don't want to pay anything, so they'll claim just cause for something that isn't just cause, and that's one of the reasons why I have a job. So, in a situation where if you've ever been fired and they paid you $0, you need to talk to an employment lawyer right away, because it may be that isn't correct. Okay. Well, I mean, most of the time it's probably not correct, but again, if you stole from the company, from your employer, then probably it is correct. But otherwise, you should be entitled generally to severance if you've been terminated. Martin again. My brother works in sales and has a commission bonus as part of his contract. Can the employer change the percentage of his bonus due to COVID impacts on the business? Well, it depends what's in the contract, right? So if the contract says, hey, we can change what we pay you at any time, or the bonus is discretionary, so a lot of businesses smartly are moving away from paying you commissions to paying you bonuses, which they claim are discretionary, but are actually commissions, because it gives them flexibility to say, well, you never had an entitlement to this. It's not contractual. Now, if you get a commission bonus every year for 3 years, then, the law is not stupid. It forms part of your compensation at that point. Like if 50% of your compensation is base salary and 50% is commission bonus, and then you get fired and you're owed severance, the severance is going to be on your total compensation, not just the base salary. But if you were fired after 1 year, it's probably based on the base salary. So, that's why employers do things like that. Listen, if you're in sales, I learned at a very young age that businesses are always trying to restrict. They need salespeople to make money for the business, but they're always trying to restrict their compensation because they make too much money. And so it's an ongoing battle. And can they change the percentage? It depends on what's in the employment contract, and your brother might want to take some time to speak to an employment lawyer to assess that. But let's just say they can't, right? Let's just say they are in breach of their contract with your brother. There you go. Contract reviewed. Contact us at help@employmentlawyer.ca, and 1-855-821-5900. Okay, so they can't do it. Well, what's his recourse? Well, if it's a big enough reduction in compensation, he could trigger a constructive dismissal if that made sense contractually, like if he was entitled to reasonable notice. But then in that situation, he's going to get severance and he won't have that job anymore. And if it's a lucrative job, maybe he wants to stay, right? It just depends. Or if the cut is huge, then so you got to remember that if the cut is big enough, he's entitled to common law severance, so he wants to go, the severance is going to be at his pre-cut amount, right? So it certainly might be worth it to pursue. But if it was a small cut and he wants to stay there and continue to make money, then he's got to weigh those options. So your brother definitely needs to talk to an employment lawyer. All right, last question. It seems, unless another one rolls in. Don, can my employer move me to a new location that is over an hour away from where I currently work? Oh, that's a great question. And I don't know if my answer is going to be satisfactory. So if it is contemplated in your employment contract or in the implied terms of that contract or oral terms of the contract, this is assuming the contract itself doesn't limit you to only the writing that's in the contract in terms of implied or oral terms. If it's in the contract that they can move you, then they can move you, right? But if it's not, and they want to move you, well, it's an hour away from where you currently work, but I would probably assess that in terms of reasonableness of commute, right? So, you know, you live in Lower Mainland, and now you've got to commute from Langley to Vancouver, so an hour drive, something like that. You know, is that on the edge of reasonableness? Yeah, it probably is. It might not be. I mean, an hour is usually the benchmark that I give in terms of what's reasonable and what's not. Like, you know, a 2-hour commute is not reasonable one way. Is 1 hour? Yeah, there's lots of people who do that. You know, there's plenty of people who commute from Langley to Vancouver every day and back. But it's from where you are, not from your old location, right? Like if your total commute isn't that bad, then you're probably out of luck. But again, the question, Don, for you is, well, you know, a lot of times people come to me and they think that I can force the employer to behave in a way that they want it to behave, and that's not what I can do. You know, if it doesn't have the right to move you but is moving you anyway, okay, well then your solution may be to trigger a constructive dismissal, you know, where the employer's conduct is effectively a termination, so you can get severance, but then your remedy is severance and you don't have that job anymore. And maybe you want the job, although, I mean, it's a really hot job market right now, so maybe you want to kick the tires on something else. But you know, so you've got to. There's no way to force them to do what you want them to do. So you're going to want to talk to an employment lawyer. I know I keep saying that, and unfortunately, for a lot of you, it's very, like, your questions are. I'm trying to answer them with the general information you're giving me, but a lot of you require sort of specific nuance and an analysis of your facts and your employment contracts and so forth. So, Don, I would encourage you to talk to an employment lawyer. We have to leave it there, unfortunately. I'm out of time. Don, you can reach us at help@employmentlawyer.ca, employmentlawyer.ca, 1-855-821-5900. Unfortunately, there was one question I couldn't get to, but great questions today. Thank you for them. They were wonderful. Chris, you can join us on Monday, June 27th with Chris Justice. I'm away. I don't think I'm around for you. I usually do this every 2 weeks, but I don't think I'm around for the one in 2 weeks, but I'll have to assess. But otherwise I'll see you in either 2 weeks or a month. Otherwise, join us on June 27th with Chris Justice, and he'll continue to answer your employment law questions. All right, everybody, great questions. Thank you. Have a wonderful and safe weekend, and we'll see you soon.